Welcome to Warrants. Yeah, that's a sentence no one ever says, but here we go. So, today we're going to be looking at warrants, an important part of the judicial process, people's legal rights, and the vast quantity of legal paperwork that exists in the world. So, let's get started. So, what is a warrant? So, if you were to look in the Merriam-Webster dictionary, which we have a copy of in the back of the class somewhere, you would see it describes something as a precept or writ used by a competent magistrate, authorizing an officer to make an arrest, a seizure, or a search, or to do other acts incident to the administration of justice. That's how they would describe this thing we call a warrant. So, in a nutshell, what they're saying is it's a legal right or a piece of paper or document that is issued by a magistrate, meaning a judge or some other civil official. And it authorizes an officer of the law, so a policeman or some other type of court officer, to either arrest, to take, to search, or to do something related to administering justice. So, there are several different types of warrants, and we're going to go into the description of these different types of warrants. Now, bear in mind, this is not an exhaustive list. There may be a few other specialty warrants that exist that are not covered by this lecture. And once again, as with all legal things, I am not an attorney. I can give you the basics of any legal breakdown, but if you have specific questions, probably best to consult someone with a law degree, not someone with a history degree. Just a word to the wise. So let's continue. So what is an arrest warrant? So an arrest warrant authorizes the police to place someone under arrest. Now, this is not the only circumstance under which a person can be placed under arrest. So if someone is apprehended while in the process of committing a crime. So, you see this on TV 100 times. The guy is in the process of robbing a bank or killing someone or robbing a store or something, and a cop shows up and they slap him in handcuffs and place him under arrest. Yeah. They don't need a warrant for that. They just saw the person commit the crime. That's fine. However, if the police want to go to someone's house and arrest them, they're usually going to need an arrest warrant for that. And it requires probable cause. What probable cause means is logical reason to believe someone committed a particular crime. So an example of probable cause might be we have an eyewitness that put them at the crime, or they match the description of the person who committed the crime. So, I don't know, they saw a murder and the gentleman was wearing a top hat and an old school trench coat. So it was Jack the Ripper. But anyway, if someone happened to be known to wear that kind of garb on a regular basis, that might be a logical reason to believe that they committed the crime, especially if security cameras also placed them in the area of the crime at that night, or it was along their usual commute. That might be the kind of thing the police could use to say, okay, we want a warrant to place this person under arrest. Now, again, an arrest is not the same as a conviction. If a person is arrested, they're simply taken into police custody. That does not mean they've automatically been found guilty of the crime. Someone could be arrested and then released if it's found, so take the example I gave earlier of the guy our fellow wearing the trench coat and the top hat, who looks like Jack the Ripper, and a murder was committed by a man matching his description. And this is this gentleman's usual commute to work. So the police arrest him, but if there's no evidence that ties him to the crime, he might be released. So that's the basics to remember with an arrest warrant. Now, a bench warrant is a different business entirely. So a bench warrant is issued by a judge for contempt of court. That means that a person is violating the rules of court. So contempt of court can include outbursts. The judge tells someone not to say something when they're on the stand or not to act in a certain way and they do it. that can be found to be acting in contempt of court. Or if you try to attack a witness, that can be contempt of court. Or attack the accused in open court. That's happened a few times on videotape. That is also contempt of court. However, the most common causes for a bench warrant include skipping bail or ignoring a summons or subpoena. So just to explain those two. So bail. When an individual commits a crime, bail is not get out of jail free money. A lot of people have a misconception about what that is. What bail, also legally called bond, refers to is when an individual is arrested and charged with a crime, it can take a good deal of time for the courts to arrange a trial because they have to find a judge. If it's a jury trial, they have to select a jury. The lawyers have to be involved. There have to be agreements over what evidence is going to be admissible and inadmissible in the court, and all of that can take time. Now, whether that person is sitting in jail while awaiting their trial or whether they're allowed to roam free, that's an important question. And if someone is accused of that crime, that's a question they have a very particular answer they want to hear and a very particular answer they do not want to hear. So if someone wishes to not remain incarcerated for the months that it often takes to arrange a trial, because many trials take weeks, if not months, to arrange. And so in order to do that, they act what's called post-bond or post-bail. So what that means is they give the judge, they give the court a certain sum of money. And the agreement is that when they return on the date of their trial, that money is returned. It's not get out of jail free money. It's not I pay this and then I'm off the hook. That's a fine or that's a bribe. Those are different. Bail is you've been charged with a crime. You'd rather not wait in jail while the lawyers are getting everything together for the trial. So you're going to pay the judge, basically you're going to give him a guarantee that here's several $1,000s. I'm coming back for that several $1,000s, so you know I'm going to be back for trial. Now, if skipping on bail refers to when a person pays that sum of money, they are released from prison, released from jail, awaiting their trial, and then they decide not to show up for trial. That's called skipping bail. If someone does this, a judge can issue a bench warrant. Now, the other reason for this is ignoring a summons or a subpoena. So in many cases, someone may be called into court not because they themselves are on trial, but because they are wanted to be a witness at a trial or an expert at a trial. And if they are needed, a judge can issue a summons or a subpoena, a document that orders them to come to court on a certain day and time to give testimony to the court. If they ignore a summons or a subpoena, a judge can issue a bench warrant. And basically what that means is the police, if they see a bench warrant, they are allowed to arrest the individual and bring them to court. So most people that have a bench warrant out on them either skipped bail or they received a summons or a subpoena to appear in court at a certain time and they did not do it. So that's the deal with bench warrants. Search warrants. Now, a search warrant is a document that authorizes the police to search private property for evidence of a crime which they have demonstrated probable cause would be there. So, in other words, this does not mean that a search warrant lets the police just to search your home because, I don't know, they heard you have the new Xbox and they want to see what it looks like this Christmas season. It's not it. What a search warrant means is that they have reason to believe that there is some evidence of a crime which is located on a piece of private land or building or some other type of private property where they would not normally be able to walk in, so they need the judge to give them permission to enter that piece of property to search for evidence. Now, warrants are a tricky business because they can be either very broad or very narrow. So they could be broad, say an entire piece of property, right? You know, the police want to search an entire farm, you know. So the farmhouse, the barn, 40 acres of land, they want to search all of it. And under that warrant they can. Or it could be as small as a single room. The crime is described as happening in a particular room of the house, and so the warrant only authorizes them to search that room of the house. Now, it's important to remember, evidence obtained without a warrant may be inadmissible in court. Now, again, there are circumstances where evidence does not require a warrant. So, for example, if it's something that's evidence that's out in public, does not require a warrant. So if someone stabs another person and they leave the knife lying out in the street, the police do not require a warrant to pick up that knife. If it's clearly visible from the public street, so say someone kidnapped someone and left the left the person tied up and unconscious in the back of their van, and the van has glass windows and the cop is walking by, giving traffic tickets, and looks in and sees the person tied up. They don't need a warrant to enter in that case. But if there's an accusation that someone has, I don't know, an illegal distillery in the bottom of their basement, and that's not something you can see from the streets, and the police just decide, I'm about 90% sure I smell moonshine, I'm going to bust through the door and go in that basement, well, then that's inadmissible. Even if they see the whole thing, it's inadmissible. That evidence cannot be presented in court. That's also why the technicalities of a warrant are very important. So if, let's use the example of that farm I mentioned earlier. Let's say it wasn't the whole farm. Let's say the police had a warrant to search the farmhouse, but not the barn. So if they search the farmhouse and there's nothing, but, Deputy Dunlap decides to walk out to the barn and sees the dead body and an entire videotape collection of this guy's 18 murders all out in the barn, guess what? All of that things he just saw, inadmissible. They cannot be used in court because that is an illegal search. The deputy was not allowed to go in the barn. The warrant only allowed him to go in the house. So if he goes in that barn or anywhere else on the property and finds evidence of the crime, that evidence is inadmissible in court. The only way it could be admissible would be if he had a reason, a probable cause to enter the barn. So let's say he actively heard a victim screaming coming from the barn. Then he could enter the barn, and if he saw the evidence, then that's okay. But otherwise, no. So, the importance of warrants. So one major example that a lot of people will find in their day-to-day lives is that one does not have to let the police onto their private property without a warrant. In fact, many have said that if the police say they have a warrant, don't open the door. Ask them to slide the warrant under the door so you can read it before letting them in. That's something that's been repeated on multiple civil rights organizations' websites, etc. Is that tip, because a lot of people will open the door, and the problem is if they see it when they open the door, then they may have probable cause to enter. So again, these are the details. And again, this is not arbitrary. There are certain circumstances where this doesn't apply. But as a general rule of thumb, that's the importance of warrants, because it gives the individual a certain level of privacy within their own home, within their own land, that the police are not allowed to violate. And if they do violate that, then anything they find when they do may not be admissible in court. So they may not be able to use that against the person. So I hope you all enjoyed warrants, a rather important part of our legal system.